Attention everyone, this is an announcement. Ijarah, a term or concept used in Islamic commerce. Ijarah simply means when one party transfers the right to use his property or item to another party for an agreed consideration. Ijarah was practiced long before the time of Prophet Muhammad, peace be upon him. During that time, it was common to rent livestock or beasts for burden to work on plantations, carry loads, mill grain, and pull caravan.
Oh, interesting. I wonder whether I can buy a plane with Ijarah.
Yes, you can.
Huh?
Ijarah literal meaning is to rent, to give something, or to provide services and goods temporarily for a wage. Attention everyone, this is your captain speaking. There are several types of Ijarah. Firstly, Ijarah Thumma al-Bay', which is ITAB. ITAB simply means that when a customer leases a good and agrees to purchase it by the end of the lease. Two contracts involved in this type of Ijarah, which are Al-Ijarah, which is renting, and Al-Bay', which is sale. So, at the end of the leasing period, the bank will sell and transfer ownership to the buyer for a minimum price. So the second one is Ijarah Al-Muntayah Bitamlik. Similarly to ITAB, this Ijarah consists of two contracts, which are the leasing contracts and the sale contract. However, the sale contracts in Muntayah Bitamlik is an option given to lessee, whereas in ITAB, sales contract is part of the contract. In Ijarah Muntayah Bitamlik, transfer of legal title will occur gradually during leasing tenure. Last but not least, we have Ijarah Mausufa fi al-Dhimmah, which means forward Ijarah. To understand it, forward Ijarah is the leasing of something such as home, office or factory that is not yet produced or constructed.
Ladies and gentlemen, the Ijarah legal requirements for Ijarah contracts pamphlet can be found in the pocket of the seat in front of you. Ijarah contracts are governed under Islamic Financial Services Act 2013 and Development Financial Institutions Act 2002. However, Hire Purchase Act 1967 is demonstrated in contracts in respect to repossession. Passengers are welcome to go through the pamphlet for the specific sections and subsections under IFSA and DAFIA and Bank Negara Malaysia's Ijarah policy document for further clarifications.
Oh, how about Shariah requirement?
On the right side of the pamphlet, among the fundamental Shariah requirements for Ijarah contracts are the components and the asset classifications. Ijarah components include the contracting parties, ijab and qabul, asset and usufruct, and also rental. As for the asset classifications, the asset can either be tangible or intangible. Besides, the asset must be recognized by the Shariah, has value and is in existence, identifiable, accessible, deliverable, not debt-based, and non-perishable. However, the classifications mentioned do not apply to Ijarah Mausufa fi Zimmah. Most importantly, the asset list must be owned by the lessor.
Hey, you wish to own a plane, right? So I work as a banker before this. Maybe I can help provide you with some information on the operational requirements of Ijarah financing. The first thing that you should know, an Islamic financial institution needs to comply with the policy document issued by BNM to ensure that all the terms and conditions are clearly stipulated in the legal documentation and consistent with the Shariah requirements. Among of the content is to clearly determine the structure of Ijarah financing that consists of its salient features, the costs and expenses, the rental payment, contract termination, resolution mechanism to address arising problems, the salient feature or the concept of another Shariah contract such as Bai', Hibah, Istisna and Wa'ad, the rights, obligation and the expectation on all parties. You know what? There are comprehensive risk management policies and procedures to effectively manage risk. It works by setting a limit on the financing base to value ratio and the maximum tenure, security deposit and provision for takaful. So these operational requirements are aimed at complementing and promoting sound application of the Shariah principle.
Oh look, this is the model for Ijarah operation.
And
And I have surveyed some banks regarding to Ijarah contracts, such as Maybank Islamic, that provide Ijarah term financing I contract that based on Ijarah Mutaya Bitamlik. And I think SME Bank provide Ijarah that based on ITAP. And also, I know that Bank Muamalat provides Ijarah leasing contract.
Since we are on this topic, I found out that there is a contradiction in the practice of banks and theory. For example, the current practices of ITAP are not strictly following the ideal Shariah standards in terms of asset maintenance duty. Theoretically, the bank should cover all the maintenance duty because they have the ownerships over the Ijarah asset. Yet in practice, the lessee is obligated to cover the cost for the leased asset, including the maintenance costs, damages and losses. I think it would be unreasonable for the lessee to cover all these costs of Ijarah asset as they have not purchased the asset yet. The lessee is only entitled to be accountable for the damages that were caused by their own negligence or misconduct. So I would recommend a comprehensive documentation for the Ijarah agreement that includes the obligations of banks, deducting takaful costs and the maintenance costs. This is to ensure that the bank is playing their part in paying takaful and maintenance.
Oh, I see. Oh, last month, I travelled to Pakistan accompanying my friend as she had to migrate there for work. So we went to the Islamic Bank in Pakistan to apply for a car lease. But I noticed that the officers in Islamic Bank in Pakistan lack knowledge and experience. They do not know clearly about the rule of depreciation in the account of car leasing. The officer did not calculate the depreciation amount for Ijarah contract that they might have problems by not recording the depreciation amount in their financial statement. For me, I think the bank officers in Islamic Bank in Pakistan should have at least basics principle and proficiency in Islamic Bank if they want to provide that kind of services to the customers, right? I'm scared that they will give the wrong information to the customers and the bank will not provide the real value of the Ijarah to customers if they are not improving their knowledge about Ijarah, right?
Yes, it is true that the theory and the application differ. Did you know that in theory, the lessor holds the ownership over the Ijarah asset while the lessee only holds the usufruct? Yet in practice, the bank as the lessor holds the beneficial ownership while the customer as lessee holds the legal ownership of the Ijarah asset. Nevertheless, SAC BNM recognizes both beneficial and legal ownership in ITAP. In my opinion, IFIs should be the legal owner. It is unfair if the customer is the legal owner because the customer will only be benefiting from the usufruct throughout the lease period. Cabin crew, please take your seat for landing. From this discussion in this flight, we can conclude that the current application of Ijarah in IFIs is not strictly adhering to the Shariah standards. Continuous and rigorous efforts must be put in place to reduce the disparity. Shariah scholars should revisit their views on the application in Ijarah as there are many untapped discussions in this matter.
Ladies and gentlemen, fasten your seatbelts. We are ready for landing. Thank you for flying Ijarah Airlines and welcome home.